which I respect the argument, that it is my right to choose my sexual orientation. Choosing a sexual orientation is
not right to choose sexual orientation. They say sexual orientation is given to me.
Incest is not uncommon in the world. And world over, incest is prohibited. That I am attracted to my sister. I get, who are you to decide with whom? I have my sexual orientation. It may be, my lord, a little far-fetched.
That would be far-fetched.
Lord, we used to
obviously
treat
a reasonable restriction. You can't have.
We used to treat even this as far-fetched.
But
it is only in exceptional cases where the state
that would be also very an extreme statement of law if they have made that statement.
No, I'm saying something else, my lord. I can't even. I'll just complete that. The argument was, first, let us see degrees of prohibited relationship. A man and any of the persons mentioned in part 1. So one class of relatives. And a woman and any of the persons mentioned in part 2 of the said schedule. Another class of relatives. Are within the degrees of prohibited relationship. There is a prohibition to marriage. Correct, my lords? Now the argument was
cumulate.
To apply both to both.
Cumulate both.
Correct, my lords. So the first, that would be necessarily rewriting.
Right.
Second proposition which I must mention here at this stage itself. Lord, would your lordships, I'm posing a question to myself, would your lordships read a particular enactment in such a fashion that it applies in a particular manner to one class, that is heterosexuals, and in a different manner to different class, namely homosexual, I say same sex, the broad category, my lord, we have identified. My lord, that exercise, my lord, may not be a permissive interpretative exercise. So to create a class within.
This is what the gesture that I made was. When I'm looking for same sex, I don't wear this. But when I'm looking at heterosexual marriages, I look at it, they act like this. So is this two-way or three-way switch possible in interpretation?
Correct. So, my lord, in my respectful submission, the statute cannot be read to mean A for some class and B for some class. And second, my lord, this is my apprehension, and I must, my lord, share at the outset. And kindly, my lord, examine this a little seriously. Lord, why this degrees of prohibited relationship? I'm not on, my lord, reworking or restructuring.
By the way, interestingly, are these degrees of prohibited relationships pretty much the same as that would are they lifted from the Hindu Marriage Act, or where do they come?
Sagotra and Sapinda relationship.
Sapinda, absolutely.
They are now codified, my lord. Because, my lord, apropos, my lord, Justice Bhatt's query yesterday, this entire debate.
Itemized elucidation in the
things also.
Yes.
One is the Sapinda, which is you go to the same ancestor, lineal ancestor, and the male linear and the female linear. That originally Shastrik it was 7 and 5. Now in the Hindu Marriage Act it is 5 and 3.
Correct.
Section 5. That is one part where you're talking of uterine blood, etc., where there is blood relationship. There is non-biological relationship also when you're talking of in-laws. So, relationship by marriage. Even there is proscription on that.
That is also prohibited.
It is also there. And this applies equally to all religions and all castes.
My lord, my worry is different. My lord, at this stage, I am, my lord, flashing it. And kindly, my lord, listen to this concern, my lord, very carefully. My lord, what is the fundamental argument of the petitioner, which I respect the argument, that it is my right to choose my sexual orientation. Choosing a sexual orientation is
not right to choose sexual orientation. They say sexual orientation is given to me.
I'm on Nautage.
I'm entitled to my autonomy by virtue of my sexual orientation.
Correct.
And a recognition that goes with
sexual orientation is not a matter of choice, but a matter of immutable features.
My lord,
that's the argument. I mean,
there are, my lord, there are two ways, my lord. There are two different schools of thought. One say it is acquirable also. Another say that it is inbuilt in the person when a person is brought. Let's not go into that. I'm slightly on a different point. But freedom of sexual orientation is held to be a fundamental right. Someone is attracted, a man is attracted to man, that is considered to be his privacy issue, and he can enter into that kind of a sexual activity the way he thinks he gets the maximum satisfaction. That's my lord, broadly. My wordings may not be accurate or my lord may be proper also. That's that Navtej Johar. Lord, kindly visualize a situation after 5 years down the line, based on this very thing, that from the beginning, I am attracted to those persons who are mentioned in the degrees of prohibited relationship. Incest is not uncommon in the world, and world over, incest is prohibited. That I am attracted to my sister, I get, we are consenting adults, we are entering into activities within the Lord privacy, and we claim our right of autonomy, our right of choice, and our right of doing something in private domain. Based on that very argument, my lord, I'm posing a question to myself. Can someone not challenge this definition itself? Why this restriction? Who are you to decide with whom I have my sexual orientation? It may be, my lord, a little far-fetched.
That would be far-fetched.
Lord,
So
we used
it's
to
obviously a
treat,
reasonable restriction. You can't have.
we used to treat even this as far-fetched.
But you know, Mr. Solicitor, sexual orientation or your autonomy as an individual can never be exercised. All aspects of marriage, including the entry into marriage, the prohibited relationships, the grounds on which marriage can be dissolved, these are all subject to regulation by law. So it may be very far-fetched for anybody to even argue before us that orientation is so absolute that I can therefore commit an act of incest. No court will ever
But suppose
even countenance it.
polygamous marriage.
Forget about sanctifying it, even
Somebody can challenge, my lord, the bigamy provision.
Polygamous marriage, that's again governed by personal law, right? I mean, on the
I'm not on personal law. I'm saying, my lord, if I say that my choice is polygamy, bigamy, the state has no right to it.
Your argument perhaps could be more, I would say, if you're leading up to that, one can understand it. But these are universal rules. I think we can all agree that these are universal rules. Now, as long as they were not codified, they were accepted. And that was the law, that was the norm, that they had a normative effect. Why did the state get into it? The states thought this as a universal norm. Now, therefore, I think if you're building up and saying there is a state interest in this relationship, one can understand. What if you're driving at that this is where the state comes in?
But that's my submission.
I think their position too was conceded that when it comes to age also that there is a state interest. So there is no field which is completely autonomous in that sense.
Correct.
Even within the marriage bond, there are certain interests of the state which are legitimate, let us say.
Lord, that is, Lord, in the second limb of my submission is going to be that state has no business to regulate social personal relationships. It is only in exceptional cases where the state.
That would be also very an extreme statement of law if they have made that statement.
I'm saying something else, Lord. I'll just complete that. State has no business as a proposition to regulate any social personal relationship. That statement your lordships are saying is not it's an absolute statement. But I'm on an extension of that statement that the state can regulate certain relationships if the state feels that it's in legitimate state interest to do so.
But of course,
Lord, therefore, marriage was not a regulated social relationship. But the state, in its legislative policy wisdom, decided that we will regulate, and we can regulate only if we recognize. And therefore, under the Hindu Marriage Act or any other marriage act, we recognized and regulated. So therefore, that's a legislative choice made. My lord, leave it at that. But, my lord, again, my lord, I'm insisting, my lord, that my apprehension may, I wish it's wrong, but may perhaps not be wrong. after, my lord, few years, when your lordships were hearing Navtej Johar, all these arguments were made. The central government, my lord, said that we leave it to the wisdom of the court so far as the decriminalization of section 377 is concerned. But I specifically added in my affidavit that this has nothing to do
With marriage.
future right of marriage, inheritance,
Absolutely,
etc.
no question
etc.
about it.
And I'll just read, my lord, from
But
page
Mr. Solicitor, don't even label that. You have said that.
Yes,
No,
yes,
no,
that-
we accept your point on that.
So, my lord, a step from step 7 to 8 may lead from 8 to 9. That's what I am just, my lord, putting a word of caution. I'll, my lord, further, I'll go further.
7 to 8, where you're saying will lead to 8 to 9, that'll be actually 8 to 15.